A right delayed is a right denied. Unless you're the Supreme Court. Then it's A-OK. Welcome to Guns, Gear, and Guns with Gary Gunderson. I am Gary Gunderson. There have been a lot of new gun laws in recent years, spitting in the face of the Supreme Court, clearly going against the Bruen decision, which declared the right to bear arms in public a constitutional right guaranteed by the Second Amendment, which should have been clear all along. States have reacted to this ruling by putting forth all sorts of other bans and adding caveats to diminish this right. And then, lower courts prop up this nonsense with rulings that also fly in the face of this self-evident right. Chief Justice Roberts can complain about the attacks on the court from the presidency all he wants, but what about the attacks by state governments clearly making laws that go against your ruling? What about the bloated bureaucratic bench of the lower courts, which also clearly makes stuff up to reach the conclusion that they want? That's where we stand in general, but let's go into detail about Snope v. Brown, or the case that was challenging the Maryland assault weapon ban. You know, just banning the most popular and commonly used modern sporting rifles under a scary moniker. It was being challenged in court, making its way to the Supreme Court, and this started years ago, before the Bruen decision. The Fourth Circuit said the law was fine, and the Supreme Court sent this back to them saying, hey, we have Bruen now, do it again, which means the Fourth Circuit was wrong. But then the Fourth Circuit decided that they were right all along anyways, and just made up some nonsense saying that the weapons at issue fall outside the ambit of protection offered by the Second Amendment because, in essence, they are military-style weapons designed for sustained combat operations that are ill-suited and disproportionate to the need for self-defense. Hey idiots, they are legal in 41 states, over 40 million in civilian hands, ARs alone. They are not the danger you say, and if you go by Bruen and historic precedents, which is, what you're supposed to do, military-style arms were always protected because every type of currently available arm was once a military-style arm. Then the court also just lied, saying, we decline to wield the Constitution to declare that military-style armaments, which have become primary instruments of mass killing and terrorist attacks in the United States, are beyond the reach of our nation's democratic processes. One, they aren't the primary instrument of mass killings. Handguns still take that spot. And two, the Constitution is not yours to wield, especially when it comes to the Bill of Rights. Rights that predate government and should be considered sacrosanct over all your other nonsense. So the Fourth Circuit was told to do it again, and they gave the Supreme Court a big F you. So naturally, after years of litigation and this obvious slight by the Fourth Circuit, the Supreme Court decided not to take on the case. This is very stupid, as these so-called assault weapons are clearly protected by the Second Amendment. Justices Gorsuch, Alito, and Thomas would have taken it up, but they need a fourth to actually hear the case, and Kavanaugh said no. But in his written response said, a denial of cert does not mean the court agrees with a lower court decision or that the issue is not worthy of review, and they should and presumably will address the AR-15 issue soon in the next term or two. Kavanaugh, you beer-drinking moron, this is the Bill of Rights. What do you mean you'll hear it in a couple of years? The case has already taken years. Is there any other right where you'd shrug your shoulders and go, well, we'll get to it when we get to it? And if you don't agree with the lower court, how can you turn down hearing it? This is ridiculous. As much as we hear and like to say it's a conservative majority on the court, they're not rank and file. Roberts wants to get along and not rock the boat too much. Barrett seems to rule with empathy sometimes along with other female counterparts instead of with, the law. And even most of the others have their issues and get squishy when push comes to shove. Oh, we just ruled on something. We don't want to make another ruling too close on the same subject. You should when they clearly defy the purpose of the previous ruling. In Kavanaugh's writing, he very clearly supports reversing this law, but he's not voting to hear the case. He actually has a pretty succinct paragraph saying why they should overturn this law, how AR-15s are common, semi-automatics, just like handguns, have a variety of lawful uses, and that handguns can be more easily concealed than rifles. And he still says no. So we stand where we've stood before. The Supreme Court ignores the Second Amendment in favor of other issues, and the reaction in articles is really hanging on Kavanaugh's soon. Like that's something to take as a win or something.
When will then be now? Soon. How soon?
But it should in the next term or two, saying the assault weapon bans are safe for now. So the states and the circuit courts will be able to deny law-abiding citizens their rights for several more years, and it will take another pile of cash to try and reclaim them. The Supreme Court will simply have to feel like hearing the case, which will cost all the money and legal fees already, on the off chance they're suddenly in the mood to actually defend the rights of Americans. Oh, goody. We get to wait and see if they're in the mood. It's stupid. It's ridiculous. This is not a win. There's no good thing about the soon because it should have been now. Look, that's all for today. Slightly ranty. I hope it was informative, though. If you made it to the end of the video and want to check out other videos on the channel, please like the video and subscribe. You can also support me on Patreon via the link on the screen. Anything you want to put forth helps, and thanks for watching.